Good afternoon, and welcome to the third annual Originalism Symposium hosted by the Federalist Society at the University of Virginia School of Law. My name is Connor Kurtz, and I'm the Symposium Chairman of our school's Federalist Society chapter. On behalf of our whole committee, I'm excited to welcome you to our symposium. Before turning the mic over to our moderator, I'd like to introduce our panelists for our second panel, Originalism's Conservative Foes. Judge Gregory Maggs is our moderator. Judge Maggs serves on the United States Court of Appeals for the Armed Forces. He's a graduate of Harvard College, Harvard Law School, and the U.S. Army War College. He clerked for Justice Clarence Thomas, Justice Anthony Kennedy, and the late Joseph T. Snead. Before becoming a judge, he taught for more than 25 years at George Washington University Law School, where he also spent several years as the Senior Associate Dean and the Interim Dean. He was in the U.S. Army Reserve Judge Advocate General's Corps from 1990 to 2018, retiring in the rank of colonel after serving as a prosecutor, military judge, and West Point professor. He has written textbooks on constitutional law, military justice, and counterterrorism law. He has also authored numerous law review articles, including a series of guides to sources of the original meaning of the Constitution. Josh Hammer is an opinion editor of Newsweek, a syndicated columnist, a research fellow with the Edmund Burke Foundation, counsel and policy advisor for the Internet Accountability Project, a contributing writer for American Compass, and a campus speaker through Intercollegiate Studies Institute, Young America's Foundation, and the Federalist Society. His writings have appeared in many leading publications, and he has also published formal constitutional scholarship. Josh previously worked at a large law firm and served as a law clerk for Judge James C. Ho of the U.S. Court of Appeals for the Fifth Circuit. Josh earned his JD from the University of Chicago Law School and a Bachelor of Science degree from Duke University. He was a 2018 John Marshall Fellow with the Claremont Institute. Stephen Sachs is the Colin W. Brown Professor of Law at Duke University School of Law, where he teaches civil procedure, constitutional law, and conflict of laws. He joined the Duke faculty after practicing in the litigation group of Mayor Brown. Professor Sachs clerked for Chief Justice John G. Roberts Jr. and for Judge Stephen F. Williams of the U.S. Court of Appeals for the D.C. Circuit. He received undergraduate degrees from Harvard University and from Merton College, Oxford, and he received his J.D. from Yale Law School. John Yoo is the Emanuel Heller Professor of Law at the University of California at Berkeley, where he also directs the Public Law and Policy Program and at the Korea Law Center. Professor Yoo is also a visiting scholar at the American Enterprise Institute and a visiting fellow at Stanford University's Hoover Institution. He has published more than 100 articles in academic journals on subjects including national security, constitutional law, international law, and the Supreme Court. He has also served in all three branches of government, from the Department of Justice, where he worked on national security and terrorism issues after the September 11th attacks, to the Senate Judiciary Committee, where he was general counsel. Professor Yoo clerked for Justice Clarence Thomas and for Judge Lawrence Silberman. He graduated from Yale Law School, and he's a summa cum laude graduate of Harvard College. Thanks again to our panelists for joining us this afternoon. I'll turn it over to Judge Maggs to get us started.
Good afternoon, and thank you very much for that introduction and also for inviting me to serve as the moderator on this panel. The title of this panel, again, is Conservative Foes of Originalism. Originalism is a method of interpreting the Constitution that requires judges to discern and then follow the original meaning of the Constitution. Throughout the history of the United States, the Supreme Court reports have included many examples of originalist decisions. In old cases like McCulloch v. Maryland on the implied powers of Congress, modern cases like District of Columbia v. Heller on the right to keep and bear arms, the Supreme Court has attempted to resolve constitutional issues according to the original meaning of the Constitution. Originalism, however, has its foes. That is to say, some, indeed many jurists and scholars, believe that courts need not follow the original meaning of the Constitution when deciding constitutional issues. And of course, not all of the Supreme Court's decisions are originalist. Foes of originalism tend to advance both theoretical objections and consequentialist objections to originalism. Theoretical objections to originalism usually assert that originalism is unworkable or illegitimate. They're supported by claims such as the original meaning is too ambiguous to discern, or nothing in the Constitution expressly requires courts to follow any particular interpretive methodology, or following the original meaning is undemocratic. Consequentialist objections, in contrast, focus on the results of originalist methodology. Originalist methodology, for example, might be thought to be unacceptable because it could not produce decisions like Roe v. Wade's decision on abortion or Obergefell v. Hodges' decision on same-sex marriage. Many of the foes of originalism might describe themselves as liberal based on their general political beliefs. This is especially true for those foes who advance consequentialist objections to originalism. But in this panel, we will learn that some foes of originalism describe themselves not as liberal, but instead as conservative. Like me, I'm sure that many of you who are listening are eager to find out who are these conservative foes? What are their objections to originalism? Are these objections theoretical or consequentialist? And perhaps most importantly, are these objections persuasive or not? We're fortunate to have three very gifted speakers to help us with this subject. Mr. Josh Hammer, who has recently written an article entitled Common Good Originalism, describes himself not specifically as a foe of originalism, but instead as a skeptic of the status quo of originalist methodology. Professor Stephen Sachs, the author of Originalism as a Theory of Legal Change, has written that originalism should not be defended, or I suppose opposed, based on normative goals. Instead, his theory is that any legal change must be justified by legal arguments. And Professor John Yoo, although himself a noted practitioner of originalism, has recognized that originalist methodology does not always yield certain answers. Each panelist will have 10 minutes for remarks. They will each have a moderated discussion. We will have a joint moderated discussion for 15 minutes afterwards. And then the panelists will take questions from the audience for the remaining time. And you can enter your questions in the question and answer tab on Zoom. Well, at this point, I will turn off my video and mute my microphone, and I'll turn it over to Josh, who will speak for 10 minutes.
Thank you so much, Judge Maggs. So really delighted to be here. Thanks so much to Rachel, who I've known for a handful of years now, and everyone else at UVA Federalist Society for having me. The irony is not lost to me that I am both the most underdressed and by far the youngest and most underqualified of everyone here on this panel. So I know my place, and I'm just honored to be here. I really fond memories of my actually 3L student symposium trip to Charlottesville, a town that I've spent a lot of time in over the years. So I regret that I couldn't be there in person. Just a really, really, really lovely town, beautiful campus, and wish I could be there. But look, I guess what Judge Maggs said about my perspective on this is correct. I am not a quote unquote foe of originalism to the extent I identified as such. My former boss, Judge Ho, would probably revoke my Ho family, clerk family privilege card. I've been a Federalist Society member since the day I set foot on University of Chicago Law School campus. I was a 3-year board member of the organization. I do not identify as a quote unquote foe of originalism. I am friendly with Professor Adrian Vermeule, whose name I expect will be batted around a lot today. I more than friendly. I mean, Adrian is a friend for sure. The theory of jurisprudence that is very much a work in progress that Judge Maggs alluded to, which I call common good originalism, is based on, it was initially formulated as a direct response to Professor Vermeule, of course. And just to make sure, this is obviously a very enlightened audience, we're working with limited time, but just to kind of really give a super quick summary to make sure we're all up to speed here. The context here is that rumors started flying in the lead up to the Bostock case, the Title VII case on transgenderism last term, that the court would rule the quote unquote wrong way, the incorrect way from a social religious conservative standpoint, and specifically that Justice Gorsuch would most likely be the one to write the court's opinion. These rumors started circulating months beforehand, query where they came from. But more or less in response to that, Professor Vermeule of Harvard wrote a fairly provocative essay at The Atlantic in late March of 2020, outlining a theory of jurisprudence called common good constitutionalism, which he methodologically described as overtly and expressly being Dworkinian in terms of its methodological approach. Dworkin obviously being kind of one of the champions, the godfathers, if you will, of what we might describe today as living constitutional theory. He expressly disavowed originalism as being anything other than purely utilitarian that served a certain time and place, specifically kind of taking it back to the time of the Federalist Society's founding in the early 1980s, when the likes of Antonin Scalia and Bob Bork, among many others, started to kind of develop originalism in earnest as a more or less direct response, heavy on judicial restraint against kind of the jurisprudential excesses of the Warren Court era in particular. And Professor Vermeule's conclusion was basically that the time has come to stop doing this, and that we should instead overtly go for substantive and normative conservative outcomes, oriented through his understanding of conservatism, which I think is just accurate to say is obviously heavily informed by his Catholicism, natural law basis. So my response to that was what was then a short essay for Claremont Institute's American Mind site. I've written on this a couple of times since then. I have another essay coming out for the Witherspoon Institute's Public Discourse site over the next couple of weeks. And then I have a really lengthy article finally getting into the weeds of this coming out this spring in Harvard Journal of Law and Public Policy. So all that to say, it's very much kind of a work in progress. It's just very kind of a nascent theory of jurisprudence that I'm outlining. But before I kind of get into what quote unquote common good originalism is and what I kind of describe it and what I hope or intend it to be, I do want to sympathize with the notion that Judge Maggs expressed, which is my frustration and skepticism of a positivist, overtly positivist and or overly libertarian infused status quo. It seems to me if you go back to kind of the Federalist Society and kind of the originalist legal movement's early days in the 1980s, 1990s, it largely was kind of concerned, right, with overturning the excesses of the Warren Court. Obviously, cases like Griswold and Roe played a very huge role in kind of the public commentary surrounding originalist discourse and what it intended. Criminal justice, crime, Fourth Amendment issues were a huge part of that. Overturning cases like Miranda versus Arizona, where I think were viewed as a huge priority for kind of the first generation of originalist scholars. And it just seems to me that kind of over time that has shifted. There certainly are some popular, more kind of overtly conservative speakers and scholars in kind of the Originalist Academy and the Federalist Society speaking circuit these days. But it seems to me, based on my, I'm a 2016 law school grad, fairly recent grad here, based on just my experience being a former Federalist Society speakers chair at the University of Chicago and just my involvement in this organization, that school of thought has been kind of overtaken to an extent by very kind of libertarian leaning heavy thought that is overtly kind of Lockean, or really just kind of inherently oriented towards individual liberty or individual autonomy as kind of the greatest goods of not just normative politics, but also constitutional jurisprudence. Now, even to the extent that this was put initially in contradistinction to quote unquote conservative originalism, like I said, that variety of conservative originalism, as it was even formulated by its leading theorists, the late great Justice Scalia, the late great Judge Bork, was oftentimes overtly positivist. It was kind of predicated upon the notion that there was that any kind of moralistic underpinnings of our constitutional order, such as can be found in the Declaration of Independence, or perhaps kind of woven in the Federalist Papers. Hamilton's Federalist 33 is a great example of this, I think. That any of that didn't really have direct relevance for modern constitutional scholarship. And I guess my perspective is, thinking about the Bostock case that ultimately did happen, according to the rumors that preceded the opinion, and kind of just thinking back to just a series of just judicial failures, just one after the other over the years. I don't need to kind of beat a dead horse here, but obviously, Kennedy, O'Connor, Souter, John Roberts, Neil Gorsuch, A2 Gorsuch, right? You read Justice Gorsuch's opinion in Bostock, and it kind of seems to me to be directly intellectually downstream of the infamous mystery passage, the mystery of human life, whatever, from Casey versus Planned Parenthood, some of the worst philosophical sophistry that has probably ever been spat out onto a judicial opinion page, courtesy of Anthony Kennedy in the Planned Parenthood versus Casey abortion case. So against this backdrop, and against the fact that even this incredibly well-oiled, highly vetted, highly trained judicial apparatus, the Trump administration still produces folks like Gorsuch, I come to the conclusion that all of the above strategy is needed to kind of change the course. And that is not solely focused on theory and jurisprudence. In fact, I think theory and jurisprudence is a very small component of this, actually. I think that other factors here, and I've written a little bit about this, would include curricular reform of the law school curriculum, kind of teaching a more overtly kind of common law and natural law, even biblical law, ideally, to 1L students. It's kind of difficult to grasp how 1L students can possibly understand actually the common law subjects without understanding kind of those precedents, what Hamilton or Marshall would have called the axioms that kind of underlie all of this entire edifice. So there's curricular reform. There's any number of things to say about judicial nominations. I have personally proposed ideas such as one idea I have is I would propose a hard stop on literally nominating anyone to the Supreme Court who has specialized in administrative law as an area of scholarship or judging, which is both an over and under inclusive remedy, I recognize, but it's kind of it's a sloppy tool that I think would redound to the interests of social conservatives and kind of perhaps exclude some of the more libertarian inclined jurists and scholars who kind of focus on administrative state issues to the exclusion of the bread and butter civilizational issues. But jurisprudence does play a role here, and that kind of, and I'm running out of time and I'm extremely limited introductory remarks, but that kind of does get me to common good originalism as I conceive it, which again, initially was a response to common good constitutionalism of Adrian Vermeule, but I do think stands on its own a little bit. Common good originalism, I envision as basically being the jurisprudence of the Federalist Party, of the original party. This is the jurisprudence of Alexander Hamilton, it was the jurisprudence of John Marshall. And even though the Federalist Party had effectively died by then, it also was the jurisprudence of the great Justice Joseph Story as well. And we're all familiar from our kind of 1L or 2L common law readings or debates, the Helvidius Pacific debates, all of that. We're all familiar with how Hamilton and Madison, Jefferson sparred mightily on a lot of these issues. I guess my notion is that Hamiltonian jurisprudence, which is this notion that rather than kind of a strict constructionist, positivist legal straitjacket, that constitutional construction ought to provide for more ample room for political actors to pursue their substantive conception of the good. My argument is that not only is our actual common law inheritance, if you go back and actually read your Blackstone, Koch, and Selden and folks like that, but it actually also was the jurisprudence that was vindicated in the early American constitutional order. It was vindicated by Chief Justice Marshall in McCulloch versus Maryland. That was kind of the necessary and proper clause ruling, of course, that vindicated Hamiltonian jurisprudence to the exclusion or to the defeat, I guess, of Jeffersonian conceptions. Madison later in his life admitted, of course, that McCulloch was correctly decided and that he, I guess, had previously been wrong, perhaps, on the constitutionality of the Bank of the United States. And I'm probably already running out of time because, and I apologize for that, we'll get to this in Q&A, I'm sure, but this has a ton of implications, of course, for outside of just necessary and proper clause. There are any number of places where you can take this, but the last thing I'll say, and then I'll toss it back to Judge Maggs, is that the tool for doing all of this, the actual tool to latch onto that I kind of envision, is the preamble of the Constitution. There's been a lot of scholarship by the late Harry Jaffa and a lot of declaration-centric scholarship. And I'd be remiss if I didn't mention that today is well, it's my birthday, but it's also Abraham Lincoln's birthday, who was the greatest of all theorists of a declaration-infused constitutional order. I am not a skeptic of the Declaration at all. But it seems to me that the Declaration of Independence has a role to play in constitutional interpretation than the preamble of the Constitution, which was actually drafted and ratified by the people who wrote the document in 1787, ought to play a role as well. And the very last point I'll make is if you take a very quick glance at the preamble, there are 7 articulated substantive ends of governance: pursue justice, general welfare, secure the blessings of liberty for ourselves and our posterity, etc. And all 7 of these substantive aims more kind of directly correlate with the statesman's view of the national whole, of the good of the whole, of the good of communitarian institutions. It is much less about individual autonomy, individual liberty, individual rights maximization. So to the extent that originalist jurisprudence has kind of gone down the latter course, I think it has erroneously sided with Jeffersonian conceptions of theory to the exclusion of what our actual heritage and tradition is. So with that very terse, I'll turn it back to Judge Maggs.
Hi, this is Stephen Sachs. I've been instructed by Judge Maggs to go forward. Thank you all very much for having me. And I want to make 3 quick points today. First, that originalism isn't just a good idea, it's the law. Second, that because it is the law, some of the conservative critiques of originalism may turn out to be beside the point. And third, that in a lot of ways, these critiques are less about originalism, the theory, than about the legal profession as a whole. So why don't we start? Why is originalism the law? I do take a positive view of law. I think laws differ from place to place. And what makes something the law around here is mainly the fact that it's recognized as such. And what's very interesting about non-originalism, despite many reports of its final victory, is that it still doesn't dare to reveal itself openly in many situations. You can't go into court and say, well, judge, the original Commerce Clause is actually against us, but we had a constitutional moment in 1937 and now everything's fine. Instead, you have to treat legal rules as having a certain kind of pedigree. Either they were the law way back at the founding, or they were added some point since in some legally valid way. I mean, maybe if you really squint at Gibbons versus Ogden, you can explain why Congress can regulate the wheat in your backyard. Or if you really squint at the 14th Amendment, you can find a charter protecting the right of all persons to enjoy liberty as we learn its meaning. Now, when they're doing this, both sides do make a lot of mistakes. Some of these issues are legitimately hard, and judges are people too. So it's easy for folks to slip into motivated reasoning when the history seems unclear and something very important is at stake. But sometimes people go beyond motivated reasoning. Sometimes they say something more like what they said in Blaisdell, that, well, judge, the Contracts Clause always really recognized an implicit exception for emergencies, so it's always been okay to do exactly what the text forbids. I think that's wrong, not just as a historical or a legal matter, but also as a moral matter. You may not care what the law was in the past, but other people seem to. And misleading the public or your fellow lawyers about it is wrong, just as lying to people generally is wrong. So I don't see this positive case for originalism as lacking a moral component. To my mind, it has a very strong moral component, not only because the rule of law can be rare and precious and something that conservatives should see as a great good they should seek to conserve, but also because we have an obligation to be truthful to one another and not to misrepresent the strength of our case. So if all that's right, if originalism is the law, then what does that say about conservative critiques? Well, to some extent, conservative critiques are suggestions about how to do originalism better. They're identifying areas of evidence and propositions that the founders would have subscribed to that they claim current interpreters are underway in their assessment of the history. And to my mind, that's all for the good. But sometimes the critiques go a little bit further because what they're really critiques of is the fact that the law is somewhat less conservative than one might like. So take the issue, for example, of birthright citizenship. Is a child born in America to parents not lawfully present a citizen of the United States? In my view, the issue isn't entirely free from doubt, but the Supreme Court seems to have gotten this one right. Birthright citizenship appears to me to be what the 14th Amendment legally required. And I happen to favor that rule as a matter of policy, though I could be wrong. But the fact that it's out of step with what some conservatives today would like from the Constitution shouldn't really surprise us, because the people who adopted the 14th Amendment had different priorities than modern conservatives do, and some of them were trying to lay down a general rule that would solve some very different problems. So in that sense, whether you think today's government ought to be more or less conservative than it is, or more or less liberal than it is, doesn't really say very much about the content of the law that we already have. On some issues like speech and religion, it could be that the rules adopted in 1791 weren't quite as libertarian as the high watermark of the mid-century court. On other issues like Federal Commerce Clause regulation, they might have been more so. We just have to go and find out. In other words, an honest constitutional scholar should give originalism's conservative critics the same answers that they would give anyone else. If the problem is that we're doing originalism poorly, then the remedy for that is to do originalism well. And if the problem is that doing originalism well doesn't get the outcomes that we like, well, that's great. Go call your congressman. Now, all of this is liable to the following objection. It would be something along these lines. The conservative position and the liberal position are not similarly situated. We're trying to be even-handed over here, but the errors all really go one way. The Supreme Court never makes mistakes in our direction, only in their direction. The legal profession skews left, the academy even more so, and progressivism or liberalism or what have you is the water in which elite legal professionals swim. So our appointees end up writing Bostock and their appointees never do. Now, I'd be happy to say more about Bostock in the Q&A. I'll just note that it isn't really about originalism, and its use of textualism is controversial among liberals as well as among conservatives. And we shouldn't lose perspective. So to someone like Justice Brennan or Justice Douglas or Justice Marshall, folks like Justice Breyer or Justice Kagan might be a great disappointment. And the conservative movement has so thoroughly discredited the Brennan model of judging that we don't even notice how far we've come. Still, we can take the point that as a sociological matter, conservative constitutionalism seems rather embattled. But it's not clear what originalism as a theory, or even constitutional theory as an entire enterprise, is supposed to do about that. If you want to reform our institutions or found new institutions to give us a more balanced profession, go to it. You're not going to find some secret in 19th century public good jurisprudence that makes that political task substantially easier. And if our actual law and legal history end up not serving well as a political rallying point, then that might be a reason to change our organizing strategy, not to say that the law is something other than what it is. So while I'm happy for originalism conservative skeptics to point out where originalists are making mistakes, I think we too quickly assume that modern views were already in fashion at the founding in both liberal and conservative directions. It may be that if we do originalism honestly, lots of conservative political goals will in fact be achieved. But if not, as they say, we should act honestly anyway, even if we expect that others won't. So I'll end there. I look forward to your questions, and I'll turn it over to Judge Max.
Hi, it's a great pleasure to participate in this conference. It's great to be sort of virtually at UVA, where two of my co-clerks, Sai Prakash and Caleb Nelson, are still trying to figure out what the Constitution means after 25 years of trying. It's great to be on a panel chaired by Greg Maggs, who I met, I guess, actually, Greg, 30 years ago when he interviewed me for a clerkship and wisely chose not to hire me, for which I resent him and his entire family ever since. It's great to be here with Professor Sachs and Josh Hammer. Admired both of their work, and I've had a lot of fun working with Josh in particular on his great enterprise of turning around the Newsweek op-ed site. I hope all of you choose to contribute to it. So it's a funny program to have, because I do agree with Professor Sachs in this one point, and maybe a little bit with Josh, that we are meeting at a time when originalists should be happy and content. And so maybe we are all conservatives here because, you know, when conservatives do well, of course, the first thing we think about is it's all downhill from here. But you have to look around and say, you know, are we all originalists now? Much in the way that Justice Kagan said we're all textualists now at our confirmation hearings. There are now 6 justices on the Supreme Court who look at least to the founders' understandings when they start looking at a new constitutional question. Look around at the briefs from the second impeachment trial. If you looked at the impeachment, the House managers brief, you would think they were all originalists. You see many quotations from the Federalist Papers. You even see citations to state constitutions from 1776. I might add, by the way, that all of the House managers, I suppose, have now disqualified them from appointment to the bench under a Biden administration. And the interesting thing is, originalism seems ascendant, because when you engage in arguments, I think, with others who would not consider themselves conservatives or libertarians about constitutional interpretation, they don't seem to have a consistent theory of constitutional interpretation anymore. You really don't see defenses of, I would say, the Warren Burger approach to constitutional interpretations. You see very little discussion, even in the literature, of penumbras and emanations anymore. Shouldn't we be satisfied? Well, I think it's a great sign of actually intellectual health that even though originalism may seem ascendant, we are constantly questioning ourselves about whether it still makes sense. And so let me just give some very brief thoughts, and then my own approach to why I think originalism still might make sense, but not for the reasons set out. As everyone has said, originalism started out, the originalism of the Bork-Scalia variety started out really as a defense against the reigning Warren Burger the Warren and Burger court's approach to constitutional interpretation, which is sort of freewheeling, unlinked to the text, ungrounded in history. You may all, I'm sure you've all familiar with Justice Scalia's famous speech where he said originalism was just the lesser evil, because it was just an effort to, it was a defensive effort to stop excessive judicial creativity, let's call it. But then that leads to a problem with originalism. And the one I think Josh has referred to, and Stephen, and also Adrian Vermeule's referred to, which is that originalism may be a process, but it is non-normative, it's non-substantive. It doesn't really have values that it advances. And so in that sense, is it not inferior to other theories of constitutional interpretation? And you could read Vermeule's argument, and certainly I think Hammer interprets this way, as a kind of sort of a legal realist approach, really. The liberals have had their day with the Constitution, and they've had the majority with the Supreme Court to advance their philosophical norms. So why don't we just do the same thing? I don't know whether we need to call common good constitutionalism. You could just call it Lochner 2. We're going to do all the things now that we didn't get quite right during Lochner 1. I would just point, I'm curious, I would hear from Professor Sachs a little more. I have read his articles about this. When he says that originalism is the law, I'm not sure what the law is. I assume he means the law as sort of created by judicial decisions. But this goes to the idea of originalism process. It seems to me the Constitution itself doesn't have its own internal rule of construction. When he says, or when others, and I certainly accept the political system, at least rhetorically, seems to accept originalism, as we see in the impeachment manager's briefs, as the way to interpret the Constitution. I think it's law as in law created by a legal profession and a legal system. And so this goes, I think, to the Vermeule point or the Hammer point of, if the Constitution doesn't have its own internal rule of construction, if the Constitution itself doesn't require us to use originalism, then why aren't we free to use whatever method we like? So I am a heavy practitioner of originalism. I have killed many trees on behalf of originalism. I plan to kill many more. But my approach to why originalism makes sense is different than saying it's required by the legal profession or legal norms, or it's required just that because conservatives or libertarians in the Lochner period or conservatives today have a majority on the Supreme Court and now have the right to use the rules of interpretation to advance their substantive philosophical agendas. So I would make a pitch for game theory, which is another area I like to work in. And I think the fundamental problem is this. Put yourself in the place of constitution makers or lawmakers, even now. One of the big problems, and you're seeing it right now with ideas about getting rid of the filibuster or undoing the Byrd rule for reconciliation, or you could go on a lot of things that are being talked about right now. One of the big problems in politics is trust. Right? You can reach a bargain or an agreement on some piece of legislation, or even more importantly, the Constitution. You may be able to reach a deal, but in the area of constitutional politics and other areas of life, not all of them, but some other areas, you have situations of low enforcement or almost no enforcement mechanisms. So take the filibuster. The courts don't enforce the filibuster. The courts don't enforce the Byrd rule. How do you generate sufficient trust even to make an agreement? Because if you don't have that kind of trust, you're never going to enter into the agreement, or if you do, it's not going to be the optimal agreement. And so put yourself back at the time of 1787 or at the times of the constitutional amendments. How do you know for sure that if you make a deal, say between North and South, or between the big states and the little states, that in the future, when times change, when one part of the country or your opponents become more powerful and you become weaker, that they're going to keep their promises? The ability to even have the trust to make that promise is going to be undermined, suppose, if people say, well, the legal profession in the future is not going to be bound by what you understood the agreement to mean. It's just going to look at your text put it into the calculation machine of moral norms at the time in the future, and then come out with the output they like. Yes. I think, in fact, that's one of the reasons Dred Scott was such a disaster for the country. Chief Justice Taney turned his back on the deal at the time of the founding, that whereas slavery might be allowed within states, Congress would have full authority over it in the territories. And that Abraham Lincoln was recalling the country to the original values, not just of the Declaration of Independence, but that basic understanding of the distribution of authority between the federal government, the states, and the presidents and Congress. And that it was the Supreme Court when it said, hey, we're going to start interpreting the Constitution consistent with what we think it should mean now, rather than trying to uncover the original deal that was a contributing factor. Because then after that, the North and South can't reach a deal to head off the Civil War that either side believes that the other will obey in the future. And so let me end there. This is something I've been trying to finish as a paper, so I toss it out there. I don't really think it's an idea, but it's something I hope appeals to a lot of people in the Federalist Society, because the people in the Federalist Society are interested in both originalism and history and interested in game theory. So I hope in the end to be a peacemaker and bring these two different strands of conservative thought together. So thank you very much for bearing with me, and I look forward to the comments and questions and discussion.
Well, maybe now all of our panelists could turn on their cameras and microphones so we could have a little discussion. And before we open it up to questions that we've received from the audience, and I have already received 5 questions from the audience in the Q&A panel, maybe we could have an opportunity for a little bit of response. And Josh, maybe you'd like to say a word in response to Professor Sachs. It sounds like you and Professor Sachs both agree on a problem, which is that a lot of the decisions that are not originalist seem to go against conservative ideas, but you seem to disagree a little bit on what the solution is. Professor Sachs seemed to think, well, it's not changing originalism. It must be something else. And I think I heard you say also that, well, we have to educate and do other things as well, but you wouldn't limit your solution to that. So what would your response be to Professor Sachs?
Yeah, so I do think that, you know, look, Senator Josh Hawley, who obviously has been in the news a lot recently, but he came to the Senate floor the day after the Bostock decision and basically said that, you know, if originalism and textualism got us this, then what is the point of this whole enterprise? And of course, we can always do the like no true Scotsman thing, right? We can always say like, oh, this wasn't proper textualism, that the Alito dissent in the Bostock case was correct. I obviously agree with that proposition. But it seems to me like there is sufficient data now, 25, 30, 35 years in, that if we truly care about substantive conservatism as such, then we ought to consider at least trying to inculcate, pedagogically infuse in the academy some sort of slightly altered originalist framework. Now, again, I do identify as an originalist. In fact, the timing of this talk is actually perfect because in the new First Things magazine this month, which literally came out this week, actually, Professor Jerry Bradley of Notre Dame has an essay more or less directly responding to the Josh Hawley floor speech and the Bostock decision. The title of the essay is Moral Constitutionalism. And like me, Professor Bradley identifies as an originalist, but he identifies with the originalism of Hamilton, of John Marshall, of Joseph Story, which was an originalism that kind of took for granted that they were norms, that they were kind of natural law precepts that undergirded the entire edifice and our basic enterprise of interpreting these legal documents. To the extent we've gotten away from that, I would urge us to correct course immediately. But sure, I absolutely do think that it's an all of the above strategy. The jurisprudence is just kind of one element of this. Obviously, we should continue to focus on getting judicial nominations right. I do think curricular reform in the law school is a wonderful idea. There's any number of ideas that could be kind of hashed out there in detail. But yeah, no, to get to your question, Judge Maggs, I certainly do envision altering kind of the originalist status quo as just one component of it. But just to kind of underscore this point here, you know, Professor Yu was talking about whether originalism is required by the Constitution, which is itself a very interesting debate, of course. You know, that kind of gets into the meaning of the oath clause. At Newsweek, shortly after I took over the opinion editor reins last year, I published an op-ed from Professor Chris Green of Ole Miss on this very question. I'm somewhat rationally agnostic on that precise question. I think I agree with Professor Green's argument, and I've written this, that the oath does require some variety of originalism, but I think prudential people can disagree on that point. But from a normative perspective, a little less so than whether the specific text of the oath clause requires it, I do agree with something that Professor Michael Stokes Paulson wrote in a National Review article, I think it was a few years ago, which is he basically said that some variety of originalism is required by the very notion of written constitutionalism itself. And that does make sense to me. So I think we're kind of just talking here about what originalism was and what it ought to be rather than ditching originalism outright.
Thank you, Mr. Hammer. And Professor Sachs, Stephen, maybe you could respond to that, but also address Professor Yu's apparent disagreement that there's nothing that requires originalism. There's nothing in the Constitution that says you have to interpret the Constitution according to its original meaning. And I know you've written about that. Maybe you could say a little more on those points.
Sure thing. So I think on the first point, what is the value of originalism if it doesn't get us to particular answers the way we want? In my view, the argument for originalism as being the law is distinct from what it can actually deliver. So sometimes the law requires us to do stuff that we think is dumb. Sometimes the law is really hard to figure out, and not because we're bad at it, it's just sort of deliberately written in obscure ways. And these are all social decisions that we make. One reason why we have to keep looking at the dusty archives to find out what our law is because we have a rule that things, once they're made the law, stay where they are and don't change until something happens to change them. It's sort of Newton's first law of law that, a statute stays at rest until acted upon by an outside force. And what that means is that if we've made the social decision not to keep amending the Constitution a lot and not to update it regularly, then a lot of questions about things like impeachment or emoluments or things we haven't really dealt with for a long time are going to be solved by reference to what the law was back then. The upshot of that for our policy debates is that sometimes what the law was back then is something we're not going to like. I fully sympathize with Judge Hammer's view that we should be understanding the founders for what they actually believe. We shouldn't project back onto them a modern sort of more libertarianish view that some folks have adopted, but we also shouldn't be projecting back onto them a less libertarianish view than the one that they actually have. The crucial question is, of course, is not just what norms did they subscribe to and what purposes were they acting for, but what rules of law did they lay down, such that we are constrained, such that we can't revise them by ordinary legislation and have to use extraordinary Article 5 procedures to do something about it. Now, I think that this really then turns on Professor Yu's question, which is, well, are we so sure that this is actually the law? So in my view, law is something that's going to be determined by social facts in different places. The way that we know that the law of Canada and law of France and law of Sweden are all different is because the lawyers and people involved in the legal system in those countries just do different things and cite different sources. And the sorts of sources that we cite here, the sorts of claims that people make when they're defending or explaining constitutional propositions really are originalist propositions. You're allowed to say that new facts have produced new outcomes under an old rule, but the norms of our system are such that you are not allowed to say that the old rule has been abandoned short of amendment. And I'd be happy to say more about that in more detail, but that's the way that I read the empirics. And if that's true, if our law is just whatever the law was, except insofar as it's been lawfully altered, then the manner of interpreting the Constitution is also going to be something controlled by old law. If you look at the work of Caleb Nelson or my colleague Jeff Powell or Farrah Peterson at Chicago, there was a great deal of discussion at the time of the adoption of the Constitution of what interpretive rules would apply to it. And the dominant position was that this is a written legal instrument and it gets processed through the same general common law rules that apply to legal instruments of this type, particularly the ones that apply to statutes. So we have all these common law canons of interpretation and various things that we will use, all of these terms of art, the example of the supremacy clause as a non obstante clause, all of these devices that were available at the time and could be used. And obviously the fact that they interpreted the law back then a certain way doesn't mean that it's binding for us today. If everyone woke up tomorrow and said, we hate the Constitution, let's do something else, it would no longer be our positive law. But I think it's pretty clear that that's not what our legal system actually does. If you want to make a legal argument, in some sense, it has to be able to claim, at least somewhat plausibly, an originalist pedigree.
Thank you, Professor Sachs. And Professor Yu, I'll give you a chance to respond. And let me ask you also about your game theory. And I guess the question is, why would someone rationally think that, well, I'll keep bargains now because people in the future will then keep the bargains. I'll keep the bargains that were struck in the past because people in the future will then keep my bargains, when in fact, is there really any belief that people in the future will keep our bargains?
Yeah. So first on this the originalism as law, I just find this very interesting point. So I actually had to do a talk about when did originalism really start becoming an important theory of interpretation on the Supreme Court. So I, for fun, just tried to count up the number of times the Federalist Papers were cited by the Supreme Court during different decades. And so if you had looked at the 50s and 60s, you would have thought our legal culture and legal profession was strongly non-originalist. The Federalist Papers, even on questions where the Federalist Papers had very important things to say, rarely cited and rarely discussed at the Supreme Court. And actually, it's interesting. I mean, this is a political event. President Reagan is elected. And then from the count I had, the Federalist Papers are cited, the citation of Federalist Papers in Supreme Court opinions goes up just under 500% in the 80s, right? And then I'm sure it's even higher and higher now. So this is the question about the idea of the rules of construction are the law because they come from a certain legal culture or political culture, is that that changes, right? It's self-dictated by the Constitution. And I would have said, originalism would have been seen as a, sort of Neolithic approach to interpretation back in the days between Brown and perhaps the arrival of Justice Scalia on the Supreme Court. So does that change one's attitude about, right, whether we can say today originalism is really the law? And then in response, I guess I'm still kind of part of the Scalia and Bork school, and not really, I would say, maybe the Justice Thomas or Alito approach to originalism, in that I'm still trying to figure out with this game theory approach a way to make originalism apolitical or non-substantive. And Greg, you're completely right. I mean, I think that's the fundamental problem in politics in many ways, is how can you ever reach a bargain with anybody if you have no faith that the bargain you reach will be interpreted in the future in line with your original view? This is, Greg and I both work in the field of international law, and this is a huge problem. This is the major problem in international law, because there are no courts at all to interpret treaties in any binding supranational way. You have to have some kind of trust with the other country that they will stay within the terms of the original bargain. Interestingly, actually, on the other hand, in international law, generally, you don't look at the the framers' intent, as it were, to a treaty, which is I find actually very puzzling. But let me just take this last point, throw this point back to co-panelists, which is how do you defend oneself, particularly Josh, how do you defend yourself against the claim that what you are doing is exactly what the liberals did from 1954 to whatever you want to pick the date as the end of the Warren Burger revolution, whether it's 1985 when Rehnquist becomes Chief Justice. And because if you call for a method of interpretation, and I think that Josh and Sachs are different here. If you call for a method of interpretation, or you want to evaluate a method of interpretation with some eye towards the kind of outcomes it's generating, then how are you really different? And maybe that's the point, is that you really aren't that different, but you might as well not self-restrain you unilaterally disarm yourselves when your approach to law is in the ascendancy. But then it's just another, Lochner had its day, and then the sort of activism of the 20th century had its day, and now we're going to go back. But then it's hard to claim that the rules of interpretation are not something other than just political?
Well, I was going to turn it over to the question and answer session, but it turns out that the question that John just posed to Josh is actually part of the question of several of our people who've typed in. For example, Jacob Marsh wrote, "What's the difference between a conservative common good jurisprudence and a Warren Court style exercise of mere power whenever the text doesn't suit a judge's policy ends?" And there's several others that are like that. And so maybe we will turn it over in this way, maybe to synthesize all those questions. And Josh, how do you distinguish common good originalism, which is consequentialist in some way, from Warren Court style jurisprudence, which we all sort of assume is consequentialist?
Sure. Yeah. So this is probably the most frequent, question that I get asked about this. Still nascent and emerging and not fully developed quasi theory of jurisprudence. Look, I guess I'll start with a criticism of positivism, and I'll kind of go from there. The problem with true kind of liberal, in the sense of the term, true kind of pluralistic, true proceduralist, truly kind of Enlightenment liberal appearance to neutrality is that it's a lie against human nature, if we just want to speak at like a very broad fundamental level here. Now, look, I'm a lawyer by training, obviously, but I currently run the opinion page at Newsweek. I thankfully don't deal with news reporters. I deal with opinion columnists and op-ed contributors. But if you look at news reporters, it is a lie that a news reporter at the New York Times, the Washington Post, et cetera, can be quote unquote neutral when he or she is trying to report on an issue upon which he or she has substantive feelings. This is actually one thing that my former boss, actually, Ben Shapiro of the Daily Wire, I think gets exactly right. Ben used to say, and maybe he still does it all the time, I'm not sure, but he used to say that it would be good for the media to just get its bias out there. So it's just that we're all on the same page and we kind of shop around, get our news independently. And if I can make kind of a crass, crude analogy here, it seems to me also that it is a lie to pretend that judges can be truly, truly, truly neutral in a strict positive sense of the term. It goes against who we are as human beings. Moreover, I also, this kind of what I was saying on the previous segment, I don't think that was what was understood by some of the leading founders. I don't think the Alexander Hamiltons and John Marshalls of the world, at least, I think James Madison as well actually would agree with this, that a true kind of overt positivism was not our inheritance. I mean, just take James Madison's most famous Federalist paper, Federalist 10, the phrase public good, if you control F it, appears in there like 6 or 7 times. They really were undergirded by substantive precepts about what the good entailed and about pursuing the good to begin with. Just 2 kind of additional points. One, I'm sympathetic to certainly something that Professor Yu said at the end there. There obviously is some sort of kind of we're fighting with one hand tied behind our back sort of thing going on here, right? I mean, like again, we can always say that we are the more principled and we're taking the high ground here, but, and this is kind of the key point that I think reasonable people on the right can disagree upon. It's kind of the overarching framework, I think, of the Amari French debate from 2019, is what exactly are we fighting for? Are we fighting for kind of Enlightenment liberalism? Are we fighting for pluralism? Are we fighting for true neutrality? Or are we fighting for kind of the substantive goods of politics, going back to kind of antiquity, what the Ciceros and Aristotles, to say nothing, of course, of the Bible itself, said about the substantive goals of politics? I think that the common lawyers, from 14th through 18th century England, understood that they were, in developing the common law, that it was the latter, that the common law cannot be understood without a basis in the Bible, without a basis in kind of natural justice and natural morality. And that is my view as to what undergirded at least the predominant mindset of the American founding as well. So I kind of started with just a very harsh critique of positivism. I'm sympathetic to kind of the unilateral disarmament point. I think we've seen the results of that, and the results are not always pretty. But I do want to emphasize that my theory is different than Professor Vermeule's theory. Professor Vermeule is kind of overtly Dworkinian. He literally cites Dworkin numerous times in his Atlantic essay and in his kind of subsequent posts. I don't agree with that. I do take an originalist approach insofar as I think that the basic tools of originalism and the originalist enterprise in terms of looking at what the founders believed and what they intended, et cetera, ought to guide legal, interpreters, constructors, et cetera, in the modern times. So from that perspective, there are any number of possible outcomes that even through quote unquote common good originalism might just be beyond the bounds of reasonableness, might be outside of the construction zone, to use a popular term from contemporary originalist scholarship. One substantive issue that I think Adrian and I actually disagree upon, for example, is gun rights, the Second Amendment. He's actually very hostile to gun rights. I am a proud gun owner, concealed carrier, AR-15 owner. I'm kind of a gun nut, actually.
Not right now, I hope.
not this precise moment. But holding aside my idiosyncratic policy views on the question, I do think that the Scalia opinion Heller is just clearly unambiguously right. That no matter what you think the common good entails substantively as a matter of gun rights, that from my perspective, and people can accuse me here of just getting my policy preference, perhaps that's a fair critique, maybe it's not. I do think that the dissent in Heller is just kind of outside the bounds of interpretive reasonableness, and therefore probably should not be construed or should not be considered as kind of a common good-esque outcome. But I've been rambling, we're on limited time here, so happy to kick it back.
Great, can I ask Josh a question to follow up on that? Because
well, let me
I can't resist this.
Well, maybe you can answer this, because another question that we received was from Connor Casey, and I think he really is addressing some of what Josh just said, and I think maybe your response would be appropriate to that question too. Connor writes, preface, I write as a non-US legal scholar, but a fan of the work of each panelist. My question is, what are the fruits of originalism? As a foreign observer, it looks like originalism really dents the capacity of the state to act for the common good. One believes that the law is aimed at securing the common good and that achieving substantive conservative ends requires an empowered state. Why should conservatives remain wedded to a theory that is agnostic to the common good and anti-statist? Excessive precaution or dedication to libertarianism are the only plausible reasons I can see. And I think that is sort of supporting Josh. And so John, maybe you could respond to that question and what you were going to say to Josh as well.
Actually, the question I had to pose was that I think Josh's advancing approach that has a big role for natural law. It's quite consistent, I think, with sort of this Straussian Jaffa approach and the Claremont conservatives approach to constitutional interpretation, which came very much to the fore during the Trump years. But what's puzzled me about it is whether you think that natural law has to be used because it is what the founders believed. Sort of this is more, I think, in line with Heller. That the founders believed there was a right to natural law, right to self-defense. So therefore, it sits behind the Second Amendment's text. Or do you think that natural law is to be used now because it is just the superior theory of moral philosophy? So if natural law thinking is different now than it was in 1789 or 1791, would you say, I'm going to read that natural law principle into my decisions now? The circa 2021 version of natural law. Just to answer the question really quick that was posed. I don't speak for all of us, but it is nice to be appreciated outside one's country more than perhaps inside one's country from now and again. So thank you for the question. You could say that an originalist approach does bear that bias against the state and maybe a little more libertarian, but that's because the founders, it seems to me, wanted a very decentralized state, with a relatively weak foreign government, federal government and domestic affairs, and states playing the primary role over regulating daily life, and the federal government in charge of national security and foreign affairs and the national market. So you could, what is the variable producing originalism? Is it there are lots of conservatives who don't like this large state that we've had since the New Deal, and so they just naturally gravitate to originalism? Or is it just originalists? If you're a principled originalist, this is the outcome you accept because that's what the founders wanted. They didn't want I think one thing that seems pretty clear is that the originalism, the founders could never have imagined the enormous federal bureaucracy that we have today and all the ways that the federal government is involved in everyday life. But I think a lot of, I think there are certainly going to be people who chose originalism because they fundamentally don't like the strong nationalization of politics. But I still think there are a lot of originalists around who, like myself, who just accept it because that's what the founders wanted, even though it is well out of step with all of our peer countries in the West.
Josh, do you have a yes or no answer to that question by John?
Sorry, I was going to respond to Connor's question.
Well, go ahead and respond to Connor's question as well.
Okay, and I might need John to just reiterate what his exact question was.
Well, he wanted to know why you were following natural laws. Is it just because it's better, or is it because the framers followed it?
Got it. Okay, got it. So I'll answer Connor's question first. So Connor's question, it's really interesting when I'm reading it right now in the chat box. Is basically asking about kind of an empowered state, perhaps an empowered administrative state, for aggressively pursuing the common good. This is Adrian Vermeil Jurisprudence 101, of course. Adrian, of course, wrote a recent book with Cass Sunstein about the administrative state. I don't agree with Professor Vermeil on the administrative state. I tend to be on Philip Hamburger's side of this argument. I think that the notion of administrative state and kind of an engorged bureaucracy is not only at odds with our common law tradition, but it is inherently discriminatory, which is something that Hamburger has written a number of times. It has its roots in Hegelian philosophy and all sorts of kind of Germanic nonsense, I think, that is really at odds with kind of our Anglo-American inheritance. So I do not agree with an engorged administrative state, but I do agree with a constitutional framework that permits legitimate constitutional actors, even if they aren't unelected bureaucrats in the deep state or whatever, to pursue the common good to the extent the Constitution allows it. So I'm enough of a lowercase r Republican to believe in a more empowered Congress. I'm not a monarchist or anything like that, but I do agree with kind of reading Article 1, Section 8, and of course this is a necessary and proper clause debate that leads to McCulloch versus Maryland, in a slightly more expansive, still originalist, but expansive, non-strict constructionist ruling that would permit legitimate constitutional actors to pursue, or at least more ample room to pursue, the common good as they see it. So that's how I would respond to Connor's question. Response to Professor Yu's question, I'm certainly not I'm really not a classically trained natural lawyer. Harry Jaffer or Hadley Arkes, I am not. My argument is actually really, I think the natural law framework makes a lot of sense, but I would emphasize it perhaps a little less than those scholars were. I would emphasize it perhaps even a little less than Jerry Bradley, whose recent essay I mentioned earlier in this program. To me, the argument is more about what our actual Anglo-American inheritance is. And I kind of trace that to the common law. Now, the common law, again, cannot be understood without the natural law, without kind of biblical substantive precepts. So query whether what I'm saying actually makes a difference in the end. But I'm making an argument, I guess it's a two-pronged argument. I made this argument more so because I believe this is actually our inheritance, and simultaneously that it gets us to more substantively conservative outcomes. But look, I mean, as a Jew and someone who believes in the Bible, I'm obviously very sympathetic to the notion that there is a transcendental natural law out there as a normative matter. What the natural law entails, theologians and biblical scholars can disagree among themselves about, of course. But it seems to me that recognizing that there is some notion of capital T truth is a fundamentally conservative thing to do.
Stephen, maybe you could respond to that, and maybe in the process also address Connor's question. And I think related is Joshua Altimus's question. He writes, Professor Sachs, in those moments when custom causes the conservative agenda to be ill-served by originalism, do you think originalism gains legitimacy in the eyes of liberal jurists? And if so, is it possible for the pendulum to swing so far that liberals exclusively embrace originalism? Or will it be seen as a legitimate tool to be used by every ideology? Are we really textualists now, or will conservatives reject textualism if it consistently produces wrong results going forward? So I guess the questions are really, what are the fruits of originalism, and could one fruit of originalism be, well, if it sometimes helps liberal jurists, then maybe that will cause more judges to be originalists.
Thank you. So I want to start by making two quick distinctions and then responding to to Judge Hammer and Joshua Aldomos. So the first is between positivism and sort of other kinds of isms, especially Enlightenment liberalism. As I see it, positivism is just about accuracy in identifying the law that's prevalent in a given society. If you sent a positivist back in time to the Papal States, they would look around and say, gosh, this is not an Enlightenment liberal society, and that's not the way their law works. So there's no sort of inherent connection between positivism and a more sort of libertarian or value neutral in that sense jurisprudence. There's also no inherent connection between positivism and being sort of relatively indifferent to the moral quality of the law. HLA Hart urged positivism precisely so that you could make a more trenchant moral critique of what the law currently contains. You know, the claim that you have a duty to do what the law says is not analytic. It might turn out to be that the law is terrible in this society and we should do something else entirely. So to say that we should put our sort of positive glasses on when we're trying to figure out what the law is not to sort of give up on moral evaluation. It's just to distinguish questions of what it is and what it ought to be. So turning to sort of the application of that to originalism, if I'm right that our law looks back to the original law, and if the original law contains standards like, you know, on this topic, do whatever is in the public good, well, then that's what originalism would entail. If, on the other hand, it included rules like don't quarter troops in people's houses during peacetime, and the reason they put that rule in was because they thought that rule overall would serve the public good, then the law is the rule that they laid down and not the sort of public good justification, therefore, although that might help us interpret and sort of figure out what exactly the contours of the rule might have been. So the argument for adverting to the public good directly or to natural law directly, as opposed to adverting to it as an explanation or justification of the rules that were actually laid down, including the sort of common law rules that were prevalent at the time, is to my mind still unproven. But at the very least, you had people debating this stuff. You know, Chase and Iredell and Calder were going back and forth on whether you could invalidate a statute on a natural law basis. You know, these issues are not sort of new to us. But my claim, at least, is that current legal standards require you to look back to the founding and not to more timeless principles, except to the extent they show up there. So what does this mean for sort of the possibility of a liberal originalism, or the possibility of a pro-state conservatism? To my mind, the reason that conservatives have favored originalism is because it provided a good way of critiquing a lot of stuff that was going on elsewhere. I mean, it's not inherent in the nature of conservatism, except that they like change to be slow, to want to stick with pre-existing rules. In the 1930s, the Roosevelt fireside chats were all originalist in nature. He claimed that the court, the pre-New Deal court, was not enforcing the Commerce Clause as it really had been at the founding, and that they were Lochner-ing and inventing all this other stuff, and that what we really needed to do was get back to the expansive Commerce Clause of the founding. Now, that is an argument that's originalist in form. It might not be originalist in substance. He might have been totally wrong about what the Commerce Clause actually allowed or didn't allow. But the basic picture here is that movements that are out of power will tend to look to more sort of general theories for explaining why they're right. Now, I happen to think that originalism is right, regardless of who's citing it. But I would not expect to see a liberal originalism in full flower unless we had a very long period of conservative control, analogous to what happened in the mid-20th century on the other side.
Well, thank you, Stephen. Another question, this one's from Cody Milner to Josh Hammer and all the panelists. It is to accept the premise that there's a role for the pursuit of the common good in a flexible manner that is divorced from the text of enacted positive law. Why then an insistence that this role must be played by judges through interpretation, rather than cabining that to the inherent discretion within the executive's role? In other words, if we're just doing common good, why are we doing it through judges?
Right. So this, I think, was also one of the more popular strands of criticisms of Adrian's essay. Isn't this notion of the common good itself best served by lowercase r Republican self-governance? I strongly agree with this, by the way, as an overarching precept. As I just said in the previous segment, I am a skeptic of the administrative state. I am not a monarchist. Moreover, I wrote a piece last year in 2020 of scholarship for the St. Thomas Law Review on the judicial supremacy debate. I am a vociferous critic of judicial supremacy, which is apt because today is Lincoln's birthday, obviously, and defying Dred Scott and all that good stuff. So I am definitely a proponent of congressional power. I would not identify as a congressional supremacist the same way that there were parliamentary supremacists back in the day or anything like that, but it does strike me as intuitive that the 3 articles of the Constitution that enumerate the branches were more or less written in order of intended supremacy. So I'm definitely not trying to empower the judiciary over the other branches. But common good originalism, as I conceive it, is not a tool that is limited just to Hamilton's least dangerous branch. I think as a tool, if we accept kind of the basic departmentalist premise that the 3 branches can all engage in their own variety of constitutional interpretation, then they ought to engage in a form of constitutional interpretation that is both historically accurate and legitimate. And if you're a conservative, ideally that which aligns with substantive end goals of conservatism as such. So I do think that there is a role for all 3 branches to play in the common good or just the constitutional interpretive enterprise. And then, of course, the question is what enterprise enters in there. But look, this notion that that pursuing the common good ought to be strictly limited to Congress, to an extent, maybe, but that's just not at all intuitive to me. The preamble of the Constitution discusses pursuing the general welfare and all of these kind of sweeping magisterial clauses that oftentimes more closely align with the notion of the common good over individual rights or individual autonomy. And there's no particular notion in there to cabin that or limit it to any particular branch of government. So again, I agree with the separation of powers. I agree with the 3 branches of government, not a monarchist, not just a supremacist or anything like that. But all 3 branches have to engage in constitutional interpretation. That's the basic Lincolnian departmentalist position. The question then is, what method do you use?
Well, we're running out of time, but maybe I could address this last question to Professor John Yoo. It goes back a little bit to the game theory point. This is a question from Effie Guerra Puhal, which is, if originalism is the law, then what is the sanction for judges and law professors who reject this method of interpretation? In other words, if we pick a method of interpretation, what happens to people who don't follow it? And if nothing happens, then what have we done by picking the method?
Yeah, this goes to the discussion. Actually, I think Professor Sachs is the one that the question might be better directed at, because if it's not so. But I would just say that's why it goes
to your game theory idea, which is,
but it's why.
Like a bargain,
I see. Sure. Yeah, I mean, so if you look at the thing that got me actually thinking about this was thinking about Dred Scott and Lincoln and his discussion of constitutional interpretation in his inaugural speech and so on. So if you think about the Constitutional Convention as having this problem, you had this sharp disagreement between along different axes of the interests within during the founding period, large states, small states, North and South. Beardians would argue between wealthy and poor, democracy and people who are more Republican. And you could say it's interesting, the people who actually broke the original deal was the South, right? You could say the South sort of took over the Supreme Court, changed the rules of constitutional interpretation. Dred Scott purports to be originalist, but it really is, it's not. I mean, Chief Justice Taney tried to change the rules of what the Constitution meant because he thought he had a better way to head off the Civil War. And it was a terrible judicial mistake. What's the sanction, though? And I think this goes back actually to Josh's last point about departmentalism. If you think of the Constitution as a bargain, people don't obey the bargain in the future, and you even thought you would use the courts to enforce the bargain. And this is a functionalist defense of judicial review too, I suppose. You would expect the courts to be the ones through originalism to enforce the original bargain, and they break it. Then you have to go to the other branches of government, and you have to, you like Lincoln, you could even create like the Republican Party in a way is founded on the idea that that original bargain is broken in Dred Scott, and then you have a president who's elected who believes the original bargain was broken. So but you have to go to, but that goes to my point about, is it really law? Because if you, you don't really have sanctions within the system. And you think about it today, even I was thinking about this when Professor Sachs was talking about why it's law. I mean, yes, it's kind of, the devotion to the founders is rhetorically and politically true, right? He's quite right. No one can step into court and say, we don't care what the Federalist Papers say. No justice of the no nominee to the Supreme Court or the lower courts testifies and says, I don't care. I'm allowed to do what I want. I don't care about the history. There's this sort of, bending the knee to originalism. But when you look at the actions, you look at the circuit courts, you look at many, many Supreme Court justices in our lifetimes, you don't see actual practice that comports with originalism, and nothing happens. If you look at the generators of norms in the profession, the law schools, our colleagues generally prize these people and teach their opinions and treat originalism, as this sort of primeval approach to interpretation. So the sanctions of the system are, I would say, actually against originalists, if anything.
John, I'm afraid we'll have to cut you off there. I think we've come to the end of our time. Let me thank all three of the panelists for their very provocative and very well stated positions. And let me also thank everyone who submitted questions. I know we weren't able to get to all of them, but they are very valuable questions, and I think you've greatly contributed to the panel. So at this point, I think we'll sign off, but thank you very much.
Thanks, everybody.
Thank you.
Thanks, everyone.